What is undue hardship for student loan discharge? Have you ever wondered what it takes to discharge student loans in bankruptcy? The term undue hardship is key to understanding this process. Generally, student loans are not easily discharged in bankruptcy. A borrower must prove that repaying these loans would cause undue hardship for themselves or their dependents. So, what does undue hardship really mean? It refers to a financial situation that is more severe than normal hardship. This means that if a borrower is forced to repay their loans, they cannot maintain a minimal standard of living. The hardship must be significant and not just a temporary setback. To establish undue hardship, courts often refer to a test from a case called Brunner versus New York State Higher Education Services Corporation. This test has three main elements. First, the borrower must show they cannot maintain a minimal standard of living while repaying their loans. Second, their financial situation must likely persist for a significant portion of the repayment period. Lastly, the borrower must demonstrate they have made a good faith effort to repay the loans, such as trying different repayment plans. Some courts may also consider the totality of the circumstances. This means they look at all relevant factors, including the borrower's overall financial condition, health, and repayment efforts. Let's look at some practical examples of undue hardship. A borrower earning very low wages might struggle to cover basic living expenses while making loan payments. Another example could be a borrower with a disability that prevents them from working and is expected to continue. Additionally, if a borrower was misled by a for-profit school about job prospects and did not benefit from their education, that could also qualify as undue hardship. Even a married couple working steadily but still unable to meet basic expenses might find relief under this standard. When a bankruptcy court finds that undue hardship exists, it can discharge all or part of the student loan debt. It may also modify the loan terms to make repayment easier, such as lowering interest rates. To prove undue hardship, borrowers typically need to file an adversary proceeding within their bankruptcy case. This involves submitting evidence of their financial situation. Recently, the Department of Education and the Justice Department have set up procedures for borrowers to present evidence to the government. If the government agrees that repayment would cause undue hardship, it will not oppose discharge in court. While the standard for proving undue hardship is high, it reflects the policy that student loans should generally be repaid unless exceptional circumstances arise. When undue hardship is proven, bankruptcy offers a legal remedy for borrowers trapped in difficult financial situations. This process helps balance the interests of both lenders and borrowers by allowing discharge only in cases of extreme financial distress.